What a $1.68 billion jury award in New York could mean for survivors in Ontario. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people, and in particular survivors of sexual assault and sexual abuse, get the compensation they deserve for their injury. Today, we're talking about this recently rendered jury verdict that awarded 1.68 billion USD to 40 women who sued filmmaker James Tobeck for years of sexual abuse. While the scale of that verdict is extraordinary and may not be typical in Canadian courts, it does send a powerful message. Survivors are being heard, and the legal system is starting to recognize the long-term damage caused by sexual abuse. If you're a survivor in Ontario, you might be wondering, could something like this happen here? As a civil sexual assault lawyer in Ontario, I want to explain what's different, what's similar, and what's possible under Ontario law. So let's start with the fact that Ontario doesn't have a time limit for sexual assault lawsuits. One of the most important things to know is that there's no limitation period in Ontario for bringing a civil claim for sexual assault. That means that you can sue at any point in your life, even if the abuse happened decades ago, even if the abuser is now old or even deceased, and even if criminal charges were never filed. This is very different from places like the US, where people often only have a few years to take legal action, unless the law is temporarily changed, like New York's Adult Survivors Act, which gave a 1-year window for older cases to be filed, which is how this case was brought forward. In Ontario, you don't need a special law to sue later in life. The law already recognizes that it can take years or even decades for a survivor to be ready to come forward. The next thing to know is the damages awards are usually smaller in Ontario, but there's no cap on certain types of compensation. So it is true that damage awards in Ontario, well, in Canada generally, are usually more modest than in the US. You may not see billion-dollar verdicts here, but that doesn't mean that your case isn't worth pursuing. So here's what Ontario courts do allow. First of all, there's no limit on general damages in sexual assault cases. General damages are the amounts courts award for pain and suffering. And in most personal injury cases in Canada, like motor vehicle accidents or slip and falls, there is a cap on general damages. But in sexual assault cases, courts have said that this cap doesn't necessarily apply. So that means that survivors can be awarded more based on the serious and deeply personal nature of the harm. Another thing to know is there's no limit on compensation for damages for financial losses. So in a lawsuit for sexual assault or abuse, you can also claim for past loss of income. So if the trauma affected your ability to work, future loss of income, if your career was impacted, for therapy and treatment costs, and for medication and out-of-pocket expenses. These are called pecuniary or financial losses, and there's no limit on them. So courts calculate these based on your actual or projected needs, and in some cases, this can lead to very substantial compensation. The next thing to know is that punitive damages are rare, but they are possible in Ontario. Ontario courts may also award punitive damages, which is extra money meant to punish the abuser and send a public message. These are less common and usually smaller than in the US, especially if the abuser has already been criminally punished. But they're still possible in some cases, especially where institutions were involved or where the abuse was especially cruel or prolonged. The next thing to know is that courts in Ontario understand that sexual assault cases are different. The courts here are starting to better recognize the complexity of sexual abuse or sexual assault cases and the toll that they take on the survivor. Judges have acknowledged that survivors often need more time with their lawyers to feel safe sharing what happened. Preparing these cases in a trauma-informed way takes more effort and care, and survivors should not be rushed or re-traumatized by the process. That's why courts may award higher legal costs in civil sexual assault cases to recognize the time and care needed to do it properly. So what does this mean for you? You may not see headlines about billion-dollar verdicts in Ontario, but justice is still possible and meaningful compensation is within reach. You are not too late to come forward. There's no deadline to file a lawsuit for sexual assault in Ontario. The courts can and do award significant damages when survivors come forward, especially when their lives have been deeply affected. You don't have to navigate this alone. So at Gerry Law, we work with survivors of sexual assault across Ontario to build strong, trauma-informed cases on your timeline and at your pace. Whether the abuse happened 5 years ago or 50 years ago, your voice matters, and we're here to help you. If you want to talk about your options or learn more about what's involved in a civil lawsuit, we're here to help you, and I can be contacted at the information below, and we can discuss your legal options.